Big story that we are tracking now. The Supreme Court laid down a comprehensive set of binding instructions to all high courts to curb delays in pronouncing judgments in matters where hearings have been reserved. Now, a bench of Chief Justice of India, Surya Kant, and Justice Joymalya Bagchi directed that high courts should endeavor to deliver recent judgments within 3 months from the date of reserving them. Now, the court emphasized that the greater urgency in cases involving personal liberty, directing that bail applications be heard and orders preferably pronounced and uploaded on the same day. Now, if reserved, such orders must be pronounced the next day and uploaded on the High Court website. The guidelines stipulate what if the bench fails to deliver a reserved judgment within 4 months. Parties can approach the Chief Justice of the High Court to order to withdraw the matter and assign it to another bench. Now, in cases where only the operative part of the judgment is produced, the detailed reason order must be uploaded within 15 days. Now, recent judgments delivered in open court would also be uploaded on the High Court website within 24 hours. The Apex Court further directed that orders granting bail or suspension of sentence must be communicated immediately to jail authorities with under trials or convicts preferably released on the same day or the next day, unless they are wanted in other cases or have not fulfilled bail conditions. Trial courts have been asked to submit compliance reports to the High Court in this regard. Now, for criminal appeals or death sentences, references involving appellants in custody, benches may seek clarification from parties within 7 days of reserving the judgment. In other matters, clarification should not be sought beyond 1 month. In urgent cases likely to cause hardship, such a habeas corpus petition, criminal appeals resulting in acquittal or demolition of matters, the operative part can be pronounced in court with the reasoned judgment to be followed within 7 to 15 days. Now, the court stressed in order to ensure accountability, the Chief Justice of every High Court must put a place in system for monthly automated emails highlighting reserved cases pending before the stipulated periods. Now, to discuss more about it, Vineet Jindal, advocate and activist, is joining us. Vineet Jindal, now you have seen how the court has in fact made this particular set of regulations. Do you think it will go far out in ensuring that, you know, the justice or the verdict is delivered and there is some kind of a time frame coming in when it comes to reserved verdicts?
Yes, this is very important aspect of a law we are talking about. It is about justice. So definitely justice delivered on appropriate time, and there is time schedule fixed by the Supreme Court. That is a very good step. And I must say, the person who has been under trial or under the judicial custody, this is like like a very big relief for them, because when the bail application is putting or linger on since long, that is very difficult to them to, and it is harmful for their constitutional right also. So the constitutional rights of under trial is also there. I think the Supreme Court has very taken this initiative and very good step for the under trials and the person who has been affected of pendency of bail application and not taking decision by the high courts, different high courts in that manner, and investigation agencies who has been taking so long for filing their replies or to file a charge sheet or certain things during the investigation procedures. So this is also a very that is also alarming now for them, because if this timeline has not been taken care by the investigation agency, then also the High Court has a right to take appropriate action against the officials who has been not been taken that investigation on appropriate manner or not filing their replies in time-bound manner. So I think this is very big relief for the people who has been looking forward for their release. Their constitutional right has been saved by virtue of this particular decision taken by the Supreme Court.
Could you just explain to us, when does a court go ahead and reserve a verdict? That is, the complete argument is that the court has come to a decision, but they're reserving it. What do you mean by reserving a verdict, and why for a later day you go for pronouncing that verdict?
Look, the verdict has been reserved only when the arguments and all the other proceeding has been completed before the concerned court. So the verdict has been not pronounced, but the argument and the other proceeding before the court has been completed. It means the court is only has a step to pronounce that verdict after completing all the proceedings regarding their filing the reply of the IOs, the argument of both the side, the state and the other people, the accused counsel or the complainant counsel. So everything has been completed. Only then the verdict has been reserved. But certain times, what happened that even after verdict had not been pronounced, there sometimes the parties had filed certain application for clarification or although the investigating agency is also filing sometimes the applications. So this is something by which now the high courts in a time bound manner has to give a verdict on any of the manner, whether it is taken some kind of no either of the parties, if they are trying to delay with the intent to delay the verdict, they will file an application. Even then the high court has time frame framed by the Supreme Court, and they have to pronounce the verdict at that appropriate time within the time limit which is cited by the Supreme Court in a matter.
Also, is it an attempt to ensure that the reserved period does not, in fact, keep people who are in jail? Because the very idea of the Supreme Court has been, the bail should be the norm and jail should be the exception. So, if people have been taken into custody, they don't want that being extended by a few days or even for a few hours just because they have reserved the verdict. Was that also the kind of understanding that came into play when these regulations were put in place?
Yes, definitely. There are already so many judgments passed by the Honorable Supreme Court in this regard. Once the order has been passed or judgment has been passed to release any person who is in judicial custody or in custody, he has to release as soon as possible. This step is also in that direction. The High Court, if they have reserved the verdict, they have to pronounce a verdict as soon as possible. So the right and liberty of that person who is behind the bar, that is also been taken care, and the safeguard which is provided by the Constitution of India for the under trials also, the person who has been behind the bar also, that is a very important aspect, while the Supreme Court citing this particular timeline and giving this particular observation and direction to the high courts in this manner.